been doing this for 94 years. Our position on this topic is on the handout that was on your table. I hope everyone was able to get one. It gives a little bit of a clear description of what the League's positions are, and we have there's also a booklet that they present. It's on our website called Money in Politics, Developing a Common Understanding of the Issues, and it's a primer for the engagement of League members and fellow citizens from 2014. It was just written in May. So it shows all the history of what the League has done and toward this topic, as well as our position and other positions that we take that are relative to money in politics. So the position is, the League of Women Voters of the United States believes that the method of financing political campaigns should ensure the public's right to know, it should combat corruption and undue influence, enable candidates to compete more equitably for public office, and allow maximum citizen participation in the political process. And then on the handout you gave, it gives you other positions that we've taken on several of the other items under money in politics. We have presented or given you some 3x5 cards at your tables, and we'd love for you to listen to the wonderful speakers we have invited to speak today, and Ellie will introduce them. And if you have questions, please fill out one of the cards. Alice Harris, can you stand up, Alice? She's in the yellow. She will collect the questions, and so after the speakers have spoken, we will have Ellie will ask the questions. Please remember, this is civil discourse in this room, and do not write attack questions or anything about any of the speakers. They're here just to inform and educate us. Thank you. Here's Ellie.
Good morning, everyone. Thank you again for coming today. Just to set the backdrop for our discussion this morning, I'd like to quote some quotes from a Washington Post, August 19 article, "Wealthy political donors seize on new latitude to give to unlimited candidates." The Supreme Court this past April dropped the limits that individuals could give to political action committees. There was no limits. And since that time, the 310 donors increased their giving by $11 million in our primary elections this summer. A total of $50 million was spent by increase total because of the McCutcheon decision. Donors, there's still a limit in how much they can give to individual candidates, but donors can give to these quasi nonprofit organizations, and their names are not disclosed. It's called dark money. This expanding reach of mega donors has fueled criticism that the political system increasingly favors the rich, an issue that the Democrats have sought to make central to this year's midterm elections. Harry Reid says, power-drunk billionaires who are trying to buy the country. But many wealthy donors rejected that notion that the playing field is tilted in their favor. Baloney, says Stanley Hubbard, a Minnesota media mogul, who largely backs Republicans and conservatives. He says, the average person can get their friends together and raise small donations that amount to big donations. The engineer McCutcheon, who brought the Supreme Court decision, said, I would think everybody would be for more money in politics like I am, because we're just spreading speech. So what impact does this have in Arizona's elections? I know I read that in Arizona this summer, 46 million more than in our history was spent on, and we're just through the primary season. So what impact does this have in Arizona? We're hoping to hear more about that today. Is this a threat to our democracy? And what does the Arizona Clean Elections Law do to help mitigate the issue in our state? I'm very pleased to present our speakers today. First will be David Stringer on my right. David is a Prescott attorney, a small businessman active in local civic affairs. He is a member of the Board of Trustees of the Charlotte Hall Museum, the Prescott Historical Society, serves as Commissioner of Prescott Planning and Zoning Commission. He is a member of the Goldwater Institute, the Federalist Society, and currently serves as a general counsel to Prescott Citizens Tax Committee. David indicated he could argue on both sides, but he was happy, he's a lawyer, but he was happy today to be representing the pro-Supreme Court decisions that they've made from Citizens United that first unleashed corporations as individuals and the increased dollar amount. Next, we will hear from Loring Cannon. Loring is a Master of Social Work from the University of Washington. He's worked in community health programs in Oregon for 20 years and private practice 13 years before retiring. He started Northern Arizona Move to Amend about 2 years ago and is the affiliate coordinator. The National Move to Amend has about 160 affiliates all over the country working to bring about a constitutional amendment to get control over the way big corporations and big money are dominating our policies, our politics. Thomas Collins will be our third speaker. Thomas was appointed the executive director for the Arizona Citizens Clean Elections Commission in August of 2013. He's responsible for the day-to-day operation for the commission, a 5-member board that administrates and enforces the Arizona Clean Elections Act, including voter and public education, public financing for statewide and legislative candidates who qualify, and campaign finance enforcement. We're anxious to hear today about how you're doing with enforcing non-clean election candidates who misuse campaign finance money. So hopefully Tom will update us on that today. Prior to becoming to the executive director of the commission, he was assistant attorney general, focused on election law, appeals, attorney general opinions, including authoring and co-authoring several briefs at the U.S. Supreme Court in matters of Arizona versus Inter-Tribal Council of Arizona, voter registration issues, and the Arizona Free Enterprise versus Bennett, a public financing matching funds. He's also served as a law clerk to Justice Scott Bales and late Justice Michael Ryan of the Arizona Supreme Court. He has a JD from the University of Arizona. Please welcome our speakers this morning. Okay, David, we're going to let you start the first volley.
Thank you very much. Good morning. Can everybody hear me? I sometimes have a little trouble with these hand mics. Can everybody hear me? Yes. Good. First, let me say by way of preface that to the comments that Ellie just made, Harry Reid didn't seem very upset when Barack Obama was collecting more money on Wall Street than Mitt Romney. People are concerned about the Koch brothers, but they don't seem to be concerned about George Soros and that constituency. So it's a very selective indignation on the part of Mr. Reid, I would say. I am honored. First, also, let me apologize. The material that I'm going to be going through this morning is a little technical in some areas, and I have some quotes that I have not committed to memory, so I'm going to have to rely more than I usually do on notes and reading quotes. I usually prefer to speak more conversationally and extemporaneously, but this morning I am going to have to rely on a text, and I apologize for that. The delivery is not quite the same when you're reading. I do realize that. I'll try to make this as painless as possible. Let me say I am honored to have been invited to participate this morning in a League of Women Voters forum on such an important topic as money in politics. I'm pleased to have the opportunity to defend recent Supreme Court decisions in such cases as Citizens United and the Arizona Free Enterprise Club versus Bennett, which have protected, in my view, have protected and expanded free speech and the political life of our country. Before I get to the substance of what I would like to say, a disclaimer is in order. As Ellie mentioned, I do have some associations with local civic groups and so on. When I was contacted to speak, I was asked to provide some background, and it's true, I am a local attorney. I own a small business here in Prescott. I am active in local civic affairs. Some of you may be familiar with me through my work for the Citizens Tax Committee and the work that we did on the Prescott School Bond last year. The Citizens Tax Committee, which is an organization that often takes positions on tax and fiscal policy issues affecting our community. Sometimes we are controversial. I serve as general counsel to that organization. I'm also a member of the Federalist Society and the Goldwater Institute. I mention this because these are organizations I belong to. In no sense am I speaking for them or representing them. I'm general counsel to the Citizens Tax Committee, but I'm not here this morning speaking for the Citizens Tax Committee. Everything I say is in a private capacity, and the views I express are my own, and I just wanted to make that very clear. When I accepted the invitation to speak a few months ago, I really didn't know very much about the League of Women Voters. I knew about you, I knew that you existed. You're a very venerable organization, you've been around for a long time. But I did not know that you had submitted an amicus brief in the Citizens United case. And that was an oversight on my part. Just I didn't look it up before I accepted it. I'm not sure that it would have made a difference as I think about it, but it might have changed how I did some of my research and how I chose to present the issue. And I would have understood at an earlier point that most of you are pretty well informed on the question, and that you have taken a position already. You're unhappy with Citizens United and the progeny. The League of Women Voters identifies itself as a nonpartisan organization. As I understand it, your membership is open to anyone who signs up and pays their dues. But in reviewing your most recent newsletter, I noticed that there were a number of reprints, and the reprinted articles were all from individuals who identified themselves as Democrats. I didn't see any reprints from Republicans. I also noticed critical references to Republican members of Congress in the newsletter. I didn't see any critical references to Democratic members of Congress. I didn't check the party affiliation of your officers. So I don't know the political affiliation of all of your officers, but I do know that some of them self-identify as Democrats. I never see any of you folks at the Republican functions that I attend. So I'm not suggesting that you're not nonpartisan, because I know you don't endorse candidates. But I think that the League of Women Voters is associated and supports a lot of issues that are supported by the Democratic Party. I'm just curious this morning, is there anybody in the room besides myself who's a registered Republican?
We don't identify our party.
I'm just asking if anybody, I see three.
Yeah, no.
I see three. All right, I understand. Well, my point is that you represent yourself to be a nonpartisan organization, and in a technical sense you are, because you don't endorse. But this is an organization, I think, that has historically been associated with liberal causes and causes supported by the Democratic Party.
Ask how many are independent.
Yes.
Okay.
Yes.
We don't identify our.
Why don't you put this in the form of a question when I'm completed instead of interrupting me? You don't have to agree with me, I'm just making an observation. Let me talk then about move to amend for a moment. Who are they? Well, I checked their website and I looked them up in Wikipedia. That doesn't make me an authority, but it does give me some insight. Move to Amend was founded in 2012 by figures who have long been associated with liberal and progressive causes. Their agenda is much bigger than amending the Constitution to restrict free speech for corporations. When they use language like ending corporate rule and ending the rule of the wealthy, their language has sort of a radical leftist edge to it that one associates with organizations like Occupy Wall Street. Am I not?
Can you pull it away from the problem a little bit?
pull it away?
Yeah.
Is this better?
It's sort of
Yes.
being
Is this
muffled.
better?
Yes.
Okay. I'm not hearing up here what you're hearing out there. So is this right? Thank you. Thank you, I appreciate that. With respect to move to amend, some of their principal founders include David Cobb, who replaced Ralph Nader as the Green Party candidate in 2004. Ralph Nader, of course, has always identified himself as a man of the left. David Cobb is even further to the left than Ralph Nader. One of the co-founders of Move to Amend is a lady by the name of Ricky Ott, O-T-T, Dr. Ricky Ott. She is a co-founder of Move to Amend. She is an environmentalist with a strong anti-corporate bias, or strong anti-corporate views. She's based in Alaska, and she came to prominence after the Exxon Valdez oil spill. She gained national notoriety after the BP oil spill in the Gulf, when she made the inflammatory...
Rather than, could you please address the
Yes.
Supreme Court decisions and not the other panelists in their backgrounds? That's the subject.
I'm afraid that I need to establish some background about Move to Amend and where they're coming from.
You could certainly ask a question or after the fact, but we really want to hear about the Supreme Court decisions and why this is a good, they support democracy in our country, and that's what our focus is today.
Ellie, I understood I was invited to talk this morning about money in politics, and that there would be 3 panelists, and that this is a fair comment and background. I will move through it, but I would like to move through my comments. Okay? I'm not making any comments about anybody here on the panel. I'm talking about Move to Amend. I'm talking about clean elections. I'm talking about Citizens United.
Okay, you have 20 minutes.
I won't need 20 minutes. Thank you. I was speaking about the founders of Move to Amend. Excuse me. I was talking about the founders of Move to Amend. Dr. Ott, as I said, came to prominence after the Exxon Valdez spill and after the BP oil spill in the Gulf. And she came to notoriety when she made a statement. People were experiencing severe medical conditions and dying as a result of oil in their blood. This claim, of course, had no basis in fact. It was ridiculed by the medical community, but Dr. Ott is a co-founder of Move to Amend. Another figure closely associated with Move to Amend is Ben Mansky, the executive director of the Liberty Tree Foundation. He's a veteran community organizer and peace activist with close ties to the Green Party. Other figures include Ahmed Mayer and Matthew Rothschild, who publish a magazine called The Progressive, founded in 1909 to support liberal and progressive causes. They are not only associated with the Move to Amend movement, but also take positions on immigrant rights, opposition to voter ID, and support for labor unions. In short, Move to Amend is essentially a front movement or a front organization for people with strong liberal views and a larger agenda. They are simply opposing a larger agenda than simply opposing corporate interests. The 2 stated objectives of Move to Amend are ending corporate personhood and declaring that money is not speech. However, if you go to their website, you will find an icon saying, donate. This seems to be an implicit recognition that money is speech. They understand perfectly well that in order to exercise their right to free speech, they need to raise and spend money. This was the core finding of Citizens v. United and Buckley v. Vallejo in 1976, on which Citizens United is largely based. So they insist on the right to raise and spend money themselves, but they would deny this right to corporate America. Now, how about clean elections? Well, what we do know about clean elections is that it refers to public financing of elections. Arizona is one of the small handful of states that have tried public funding of elections. At the present time, Arizona and Maine are the 2 states with the most comprehensive programs. In Maine, it is a popular program and seems to be successful. A large percentage of their legislature runs through public funding and clean elections. However, a number of other states that have tried it have found that public funding does not live up to its promise. California enacted clean election legislation, but it was defeated by a voter referendum, 57% to 34%. Clean elections was defeated in Alaska in 2008 by 64% to 35%. In 2010, a clean elections bill failed to qualify for the ballot in Colorado. In 2013, North Carolina repealed its system of public financing of judicial campaigns. Massachusetts defeated public financing of elections in 2002 in a 2002 referendum. This history suggests that clean elections is not gaining ground, but losing it. Only a few states have tried it, and most of those that have tried it have abandoned it. Arizona has had a comprehensive program for public funding of candidates since 2000, following the 1998 voter referendum or voter initiative. However, in 2011, it suffered a major setback when the Supreme Court found that the matching funds provision in the Arizona Clean Elections Law was unconstitutional. This provision provided that when a privately funded candidate spent more money than a clean elections candidate, the clean election candidate received matching funds. This could also actually involve matching funds for a number of candidates who were running as clean elections. The Supreme Court found that this was simply unconstitutional and an unconstitutional burden on free speech. Clean elections has proven to be a viable path for election, though for some candidates. Just recently, we had Noah Campbell here running for in the primary. He was running against a well-funded traditional candidate, and he was successful. So it does work in some cases. However, in general, it has not lived up to its advertising of eliminating the problem of incumbency. Incumbents running for a public office typically have a very significant advantage. Clean elections was sold in part on the idea that it would reduce this advantage and level the playing field. So it has not really lived up to its advertising. So the question is, if it doesn't deliver on its promise, why have it? Let me now turn to the question of money in politics and the Supreme Court's ruling that money is speech, and that corporations have the same right as private individuals to contribute to political campaigns. First, I would like to note that the Supreme Court has never said, either in Citizens United or any other case, that corporations are people. If you read the decisions, you will search in vain for that phrase. It's a straw man. It's a verbal sleight of hand that interests hostile to corporations used to gain a rhetorical advantage. I believe Mitt Romney was quoted in the press in the 2012 election as saying that corporations are people.
My friend.
But an offhand comment by a candidate is not a statement of law. What the Supreme Court has said is that a corporation is an entity recognized by law that has many, but not all, of the same rights and responsibilities as natural persons. Corporate rights are primarily in the area of property rights. Corporations don't have the right to vote. They don't have parental rights. They don't enjoy legal entitlements like natural citizens. In corporate law, corporations are often referred to as legal persons. It is a legal concept. But the use of the word person does not imply the equivalence of natural persons. Legal attributes of a corporation are not laid down in Citizens United or Buckley v. Vallejo, or the First National Bank versus Bellotti, or any of the Supreme Court's decisions on election law and political speech. The idea that a corporation has some of the rights and responsibilities of natural persons is a time-honored legal principle that goes deep in our legal history. Just to lay the foundation for the court's reasoning in Citizens United, we need to understand what a corporation is. The word corporation derives from the Latin word corpus, which is the word for body, a body of people. Legal entities that resemble corporations date back to Roman times. There were laws recognizing the rights of citizens during Roman times to form political clubs, religious groups, burial societies, guilds of craftsmen, etc. These organizations were sanctioned by law as entities distinct from their individual owners. They enjoyed both rights and responsibilities. They could own and dispose of property, and they could be held accountable for their actions. Corporate form has been used throughout history. The oldest corporation surviving into modern times is a corporation, a copper company in Sweden, that dates from 1347. They've been mining copper for 1,000 years, and they're still around. So corporations go way back in our history. The law has always recognized both the rights and the responsibilities of corporations. They are authorized by law and they are regulated by law. They have a fiduciary responsibility to their owners. In the United States, there are over 5 million corporations filing federal tax returns. Most of the wealth of our country is held in corporate form. You have a bank account, an insurance policy, an annuity, retirement account, or simply invested mutual funds. Your financial security is dependent on the health and well-being of corporate America. Corporations, large and small, are affected by government regulation and public policy. So much of our personal well-being is tied to the health and well-being of corporations. Why would we want to strip them of the ability to participate in the political process? For example, if the Environmental Protection Agency wants to impose costly regulations on the Navajo generating station that would dramatically increase the price of our electricity, why wouldn't we want to hear from them as to how this legislation or how this act of the EPA, these regulations would affect them? This is political speech by a corporation that serves a societal interest. If the Arizona Power Service, APS, who we all pay our electric bill to, is impacted by the rates set by the Arizona Corporation Commission, shouldn't APS be allowed to inform voters about the position of candidates for public office who are going to regulate their business? Doesn't that serve a societal interest? So with that background, let me turn to what the Supreme Court has said in Citizens United about political speech and free speech. In 2002, Congress passed the Bipartisan Campaign Reform Act, which imposed new restrictions on political activities by corporations and unions. These restrictions apply to both for-profit and nonprofit corporations. This law was intended to remedy the perception that large aggregations of wealth controlled by corporations and unions were having a corrupting effect on elections and undermining public confidence in the electoral process. Among the provisions of the Bipartisan Campaign Reform Act was Section 441B, which banned corporations from using their general treasury funds to make independent expenditures for speech, that is, electioneering communication, or speech that expressly advocates for the election or defeat of a specific candidate. And there was a time limit set for 30 days before a primary, 60 days before a general election. Excuse me. There were many other provisions of the Bipartisan Campaign Reform Act that was discussed or dealt with in Citizens United that were upheld. In particular, the disclaimer and disclosure requirements. I know some of you are concerned about dark money, but Citizens United did not address that issue. It simply addressed the one provision about the excuse me, I lost my spot here. There were many other provisions of the Bipartisan Campaign Reform Act, including the disclaimer and disclosure requirements, which were left intact by the court's ruling. In the run-up to the 2008 presidential election, a nonprofit corporation, Citizens United, released a documentary critical of Hillary Clinton. They sought to have the film released on pay-per-view TV channel, which would have made it available for viewing within the prohibited time limits, 30 days before a primary, 60 days before penalties, because the Bipartisan Campaign Reform Act had carried both civil and criminal penalties. It was a felony to do this. In anticipation of this litigation, Citizens United sought declaratory and injunctive relief in federal courts. They lost in the lower courts, and the Supreme Court accepted the matter for review. The decision was issued on January the 24th, 2010. You may recall that was the date of the State of the Union address, and President Obama was in high dudgeon and took the unusual step of criticizing the decision in the presence of the Supreme Court justices who were in attendance. The decision was a 5-4 ruling delivered by Justice Kennedy. Well, if it was a Roberts Court decision, it was not. It was Justice Kennedy delivered the decision. And he overruled a prior precedent, but in doing so, he returned to an earlier precedent set forth in Buckley v. Vallejo and the First National Bank of Boston versus Bellotti. Speaking for the majority, Justice Kennedy wrote, "This court now concludes that independent expenditures, including those by corporations, do not give rise to corruption or the appearance of corruption. That speakers may have influence over or access to officials does not mean that those officials are corrupt, and the appearance or influence of access will not cause the electorate to lose faith in its democracy." He also said that in Buckley versus Vallejo that the government may not suppress political speech based on the speaker's corporate identity. No sufficient governmental interest justifies limits on the political speech of nonprofit or for-profit corporations. So as I read this case, Citizens United, the Supreme Court has reaffirmed the basic language of the First Amendment. Congress shall make no law abridging free speech. First Amendment protections do not depend on the identity of the speaker. They apply equally to corporations and individuals. Each of us individually possesses the right of free speech. So by what logic do we lose that right when we associate with others in some common enterprise? A corporation, as we have discussed, is simply an association of individuals. Corporations have rights because they embody the rights of the individuals who associate in corporate form. If the court had ruled individuals lost their rights to free speech where they associated with others, then individuals would have lost a right that is personal to them and guaranteed by the First Amendment. I would submit that we are all safer and more free when the First Amendment rights of both corporate citizens and natural citizens are protected by law. Thank you.